Honorable Swart.
Thank you, House Chair. House Chair, the ACDP understands the need for reform, but this is not the answer. House Chair, the bill and its scheme which it seeks to establish are fatally flawed and fail to achieve the objectives set out in the memorandum. And on the contrary, it will result in extreme hardship on future victims of road accidents, particularly those who are most vulnerable in society, including children, widows, and the poor. And every opposition party here is opposed to it, and that should give reason for thought. Now, the concepts of reasonable and equitable go hand in hand, and there can be no rational basis. That is a legal requirement to suggest that it is reasonable or equitable to support condemning seriously injured children to a lifetime of abject poverty and suffering. That is what is proposed here, with no prospect of achieving a reasonable standard of living. Is that pro-poor? Definitely not. It arbitrarily limits the benefits payable to widows and dependents of deceased breadwinners. It burdens an already failing public healthcare system by forcing victims without medical aid to use public hospitals. And the total abolition of any claim for general damages for pain and suffering, not even for the most catastrophic injury. This is disgraceful, and this is contrary to what the Satchell Judicial Commission of Inquiry recommended. And we as the ACDP have deep reservations about the bill's impact, particularly on the no-fault system. So let's just have a look at it. What is the system at the moment? You've got an innocent motor vehicle driver, you've got a drunken driver. The drunken driver cannot claim. Now the drunken driver can claim. What do you have? Double the claims. What does that result in? Double the fuel heffing. It is not rocket science to understand the implications of this, and that is why the National Treasury said it is unaffordable. So let's just have a look. To make matters worse, Section 35 totally removes any civil claim that you may have. That is disgraceful. And it removes legal assistance. So the minister blames lawyers very easily. But let's just have a look. At the moment, direct claims that are instituted, there are 200,000 direct claims without lawyers. 20,000 of those have already been prescribed. That means they've got no claim. That is disgraceful. There's another example of a claim that was instituted, direct claim. 45,000 rand was offered to those claimants. Lawyers were brought in, and the settlement eventually was 4 million rand. This is disgraceful to blame lawyers. Let us have a look. The clogs apparently the courts are clogged. What is the problem with that? The RAF, because they litigate right through to the court steps, and then they are settled there. Very few of those cases go through to final trials. So, Chair, this we cannot accept. The right to claim due and proper compensation following a motor vehicle collision, particularly where one is not at fault, is a guaranteed constitutional right which cannot be sacrificed on the altar of government incompetence, maladministration, and corruption. Thank you.
Ramatlakane, ANC.